The non-SAN conveys the point that the tribunal has no criminal jurisdiction, while the prosecution submitted that the tribunal is a court that can exercise criminal jurisdiction. It is in view of the tribunal, it is in view of that the tribunal, having considered all the arguments of counsel on both parties, it is the well-considered ruling of the tribunal that trial before the Code of Conduct Tribunal is criminal in nature, as portrayed in the case of Federal Republic of Nigeria versus Atiku Abubakar, where Justice Aboki, Justice of the Court of Appeal, ruled that the trial in the tribunal is criminal in nature. On the strength of the decision supra, I hold that proceedings before this tribunal is purely criminal. Consequently, all arguments can only be taken when the plea of the defendant is taken. It is also our ruling that the defendant, in view of the ruling, must enter the door to take his plea, and subsequently all other applications bordering on issue of jurisdiction or any other application can be properly taken afterwards. That is the order of the tribunal. Yes, let us proceed.
The Honorable Tribunal to accept the charge and allow it to be read to the defendant. Mr. Professor.
I will go ahead and proceed with the House charges to the defendant.
Hear the charge. Sir, count one charge. That you, Dr. Bukola Saraki, whilst being in the Executive Governor of Kwara State, on or about 16 September 2003, within the jurisdiction of this Honorable Tribunal, did make a false declaration in the asset declaration form for public officers on assumption of office as Governor of Kwara State by making an adversary asset declaration, in that you claim to have owned and acquired number 15A and 15B McDonald Ikoyi, Lagos, through your company Kalisle Property Limited in the year 2000, when they said properties was in actual fact sold by the implementation committee on federal government landed property in the year 2006 to your companies Teni Tea Limited and VT Oil Limited for the aggregate sum of 396,150,000, and you thereby committed an offense under Section 15 of the Code of Conduct Bureau and Tribunal Act, Cap C-15, Laws of the Federation of Nigeria 2004 as incorporated under paragraph 11, subsection 1 and 2 of Part 1, Fifth Schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended, and punishable under Section 23, subsection 2 of the Code of Conduct Bureau and Tribunal Act as incorporated under paragraph 18 of part 1, 5th schedule to the Constitution of the Federal Republic of Nigeria 1999 as amended. How do you plead? Guilty or not guilty?
Mr. Chairman, I want to state that, that I'm a true believer in the rule of law, and I've come here with great respect to that. And I believe that my presence here and before now was to look as a way of defending my rights. But I've come here to subject myself. I believe that I'm here, strongly believe I'm here, because I am the Senate President. I don't believe that I'd be here if otherwise. Mr. Chairman, I want to say that I observed that we made reference to some of the good work the Senate has done in the criminal administration. The same Senate was the one that passed the Code of Conduct Bureau Act of 2001. That clearly states in section 3D that, I just want to make these opening remarks to show that I believe in the rule of law. Section 3D says there that if there is a breach of the asset declaration, the Code of Conduct Bureau shall refer the matter to the Code of Tribunal after giving the person an opportunity to either confirm whether those facts are true, and if he admits, the matter shall not be referred to the tribunal.
Mr. Defendant.
Well, I will now go ahead. I will now go ahead because I want to explain why, Chairman, I will now go ahead and accept. I just wanted to state that for you to understand as a layman why I find I'm puzzled why I should be before the tribunal. I thought that the Code of Conduct should have first called me according to the law, because we have been talking here about the new Nigeria. We have been talking about, especially the prosecutors, been talking about Nigeria going forward. Mr. Chairman, this is the first time, and we are all watching, we are before the new world, not before Nigeria. And we all should be seen to do. I will compare myself with the due process. And that is why I felt that before now, some of those issues need to be raised. So, as stated, I want to state that I am not guilty.
Please, court in order, please. Court in order, please. This is count 1 of the charge. Please, let us listen, please. Let us listen. We need decorum, please. We need decorum. Everything we are doing there is for the benefit of all of us. So, count 2. That you, Dr. Bukola Saraki, yes, sir. The first count charge now. My lords, the first count charge, the defendant said not guilty. Yes. Count 2, that you, Dr. Bukola Saraki, while being executive governor of Kwara State between October 2006 and May 2007, within the jurisdiction of this honorable tribunal, did acquire properties after your declaration of asset on the assumption of office in 2003, to wit, number 70A and 70B, McDonough Ikoyi